All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, it shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on today's docket is In Re Amendments to Florida Rule of Civil Procedure 1.442. Counsel.
Thank you, Chief Justice, and good morning, Your Honors. May it please this court, my name is Bailey Howard, and I represent the Florida Justice Association in these proceedings. Your Honors, at the heart of the FJA's comment is a framework we propose this court should use to evaluate any proposed amendment to Rule 1.442. And that framework ultimately derives from the Florida Constitution, and it consists of three questions that are pretty straightforward. The first is whether the amendment is substantive or procedural in nature. The second is to a degree intertwined with the first, and it asks whether the proposed amendment is consistent with all of the relevant statutes, which are more than just Section 768.79, although that's the one most frequently referred to under the proposal for settlement mechanism. There are, in fact, other statutes that use proposals for settlement, and the rule should effectuate the purpose and function of those statutes also. The third question is whether it makes good sense in a public policy perspective, to make the proposed amendment in question, whether it would further the purposes of the proposal for settlement mechanism, which are to encourage settlement and to reduce litigation. And the FJA's position here, Your Honors, is basically that if we take that framework and we apply it to the proposed amendments, the logical result is what the FJA advocates in its comment, that there are some things that are inconsistent with statutes and need minor tweaks to resolve them. There are some things that are substantive and should not be in the rule because they have the potential to create confusion or to vary from the substance of the statutes that are on point. And there are some things that just don't make sense from the perspective of furthering the purposes of the proposal for settlement mechanism. So to begin with, the proposed amendments to subdivisions C2C and D are things that the FJA submits this court respectfully should approve with minor modifications. They exclude non-monetary conditions of the proposals for settlement except for a voluntary dismissal with prejudice. And the minor tweak that needs to happen here, as the FJA sees things, is that this is inconsistent with some of the statutes. There are statutes that specifically permit non-monetary conditions to be used in proposals for settlement. And in particular, that's Section 70.001, subsection 4C. It specifically contemplates certain non-monetary conditions, and Rule 1.442 applies to that statute, so that tweak is necessary. Furthermore, it's important to note that although the proposals for settlement, you can't demand something you couldn't get in the lawsuit. Something that FJA members do consider important is that payment as a condition of settlement is a monetary condition for a couple of reasons. It's one, inextricably intertwined with a monetary condition. The existence of a amount in the proposal for settlement really only exists so that you can ultimately be paid that amount. And moreover, it is something that the party could receive in the litigation because the opposing party could confess judgment by just paying the amount demanded. And then the party would be entitled to the entry of a judgment on their behalf as sort of an administrative matter for the court to close out the case. So that's a factor that this court should consider when it's determining whether to make those amendments to the rule.
Doesn't that sort of effectuate an end run, though, around judgment enforcement proceedings and constitutionally permissible defenses against enforcement of a judgment? And it is one thing to stipulate that a money judgment is in order, right? And that's why 768.79D requires that we state it's the total amount of a judgment. But there may be extraterritoriality defenses and other defenses to the enforcement of a judgment. Don't you agree?
I do agree with Your Honor. There would be extraterritoriality defenses and so forth, but by confessing judgment, a party abandons those and waives them. I mean, confession of judgment was originally an extraterritorial issue. It was a way to get a judgment in another jurisdiction enforced in your jurisdiction. And so in that sense, it's still something that would be available in the action. And so those defenses would still be available, but the act of confessing a judgment puts them beyond your reach. So I don't think it would raise the constitutional issues Your Honor brings up in the context of an amendment to Rule 1.442. But the real heart of the comment is to make sure that there's consistency with the statutes. And that should be the court's first concern here, is to be consistent with the applicable statutes. It's also important to remember there that the parties can negotiate their own settlements outside the context of the proposal for settlement mechanism. And so if there are conditions the parties want, such as releases or confidentiality provisions, the parties could still negotiate for and obtain those outside the context of Rule 1.442 and the proposal for settlement mechanism. So this court's amendments, if it did not include non-monetary conditions, except to the extent specifically permitted by statute, wouldn't place those conditions beyond parties' reach when they're important to parties. The second set of amendments, or proposed amendments, that the FJA has matters to comment on, I suppose, are the subdivisions section C2B, E, and F, which involve the incorporation of the attorney's fees, costs, and interest into the amount of the proposal for settlement. And here again, we have some conflict with statutes, because some statutes say you can't include things of this nature, some statutes say you must include them, and some statutes say you can if you want to. And so there's an issue of statutory consistency there. There's also, as the Civil Procedure Rules Committee points out in its comment, there's a potential inconsistency with the language of Section 768.79, because 768.79 says the proposal for settlement will be construed to include all damages that would be available in a judgment in the action. But that's in subsection 768.79, subsection 2. This court's decision in White versus Steak and Ale in CCM, as the Civil Procedure Committee correctly points out, interpreted subsection 6 of that statute, but not subsection 2. So the substance of the law is not necessarily in alignment with what the rules is, the proposed amendment to the rule would provide. But the omitted case canon is really the thing that's on point there, because the statute does not provide for anything beyond the damages. At least the statute on point that I'm talking about here is section 768.79 doesn't provide for anything beyond the damages to be in the proposal for settlement. Other statutes do things differently, and so that's something that this court would have to note as it proceeds with any amendments.
So your position would be that with 768.79, because it does provide for damages as the offer and not attorney's fees and costs, that if we had a rule that required inclusion of attorney's fees and costs, it would be substantively inconsistent with the statute?
Yes, Your Honor. That's a fair statement of what I'm saying.
It would also be very problematic, which you point out in your brief, correct?
Yes, Your Honor, it would.
It would be very difficult to put together an offer that it'd be easy to anticipate these are the likely damages, we've had discovery, we know what those are. This is our likelihood of success. This is what we think a jury would do. But it'd be really hard, I would think, to anticipate the attorney's fees another side might get and those kind of things. Would you agree with that?
Yes, Your Honor.
So
And
it makes it unworkable as well.
yes, Your Honor. It would
Go ahead.
I'm sorry.
Go ahead.
Thank you, Your Honor. It would be difficult not just to anticipate those things, but then to litigate them afterwards. I mean, as we explained in the comment, when you go to determine whether the proposal for settlement should be enforced and whether you're entitled to attorney's fees under it, you effectively have to have a mini trial about the damages you would have gotten anyway. And so at that point, what's the point of settling if you're going to have a mini trial about it anyway? And the same concern arises in the third set of amendments that the FJA would like to comment upon, and that's the proposed amendments to the joint proposals for settlement in subdivision C5. And there, the proposed amendment would keep a settling party in the litigation, and that's I'll rest on the comment otherwise, except to the extent this court has questions about it, but that's the thing that I would really like to emphasize to this court, is that the proposed amendments to subsection C5 keep a party that was willing to settle in the litigation. They force them to stay in it, and that party would then have to proceed and litigate the case in a sort of tautological statement, if you'll excuse me for making one. So this doesn't encourage settlement. In fact, it prevents settlement, because now that this party that was willing to settle is kept in the case. And it's unclear from the rule what would happen if that party then settles the following day in a non-Rule 1.442, non-PFS related settlement on those same terms, because now the parties know that those were acceptable terms for this party to settle on. And if they then settle on that basis, what happens? The rule doesn't answer this question.
My question, and I think Justice Lawson, because he covered it pretty well, and I think you covered on the attorney's fees part of it. The thing about these offers, the whole history of it, I was in practice in the mid-'80s when we started these offers of judgment things. And every year, either the legislature or we meddle with it. And so you have all these different statutes, different rules, and you have to look at the year when the accident happened. Kind of the same thing as stacking uninsured motorist insurance. Every year, one year you have stacking, the next year you don't have stacking, and it goes on and on and on. We keep meddling with it. And a lot of lawyers malpractice because they may have settled a case when they may have had stacking and didn't look at the statute. Same thing here with this offers of judgment. I remember trying a case in Broward County in the beginning of this offers of judgment thing where you could accept the judgment in trial. In fact, we accepted it after selecting a jury, and it wasn't one to our liking. So we took it. But now you do it within 60 days or within 30 days. It was 10 days for a while. You got to look at the year when it was enacted and then the rules enacted. It's all very confusing. And for something that was devised to promote settlement, so something that was devised to take these cases out of the judicial system and get them settled and moving on, this is just adding more complications, it seems to me, to an already confusing area of the law. The attorney's fees part of it is mind-blowing to anyone who has practiced in this area as to we know what's going to happen there. Case is not going to settle. You're not going to promote anything. And the last one you mentioned about joint parties, I mean, you're always going to have one party who happens to be in privity of whatever happened with some product. It's a small player who is not going to want to settle. And that will stop settlement. So I don't know how this promotes anything. And I would just say, leave what's broken alone. We'll figure out how to put the pieces back together. We get that Gorilla Glue, we'll do something, and leave us alone. Let's move on. That's my position.
Well, Your Honor, in that spirit, unless this court has any further questions, I'll yield the remainder of my time to the court.
I do, actually.
Yes, Your Honor.
So I understand your point that with the subsection that adds attorney's fees and costs as something that needs to be included is inconsistent with the statute, so that would be inappropriate because it would change substantive law. So we're there. On the joint proposal, your position is that the statute uses the singular party and that precludes a joint proposal. What about the statute that says that the singular includes the plural and interpreting all the statutes and the plural includes the singular as the context permits? Wouldn't that allow for that word at least to be a plural, parties?
Yes, Your Honor, except that what Section 1.01 says is that the singular includes the plural and the plural includes the singular where it makes sense for it to do so. Mm-hmm. And in this context, it doesn't really make sense for it to do so. That reading doesn't flow naturally from the text of certainly Section 768.79 and potentially from the other proposal for settlement mechanism statutes as well, because of all of the problems this court has articulated and that our comment articulates, and concerns that I think all of the commenters share in their comments with the joint proposals. There is a potential for gamesmanship. There's a potential for confusion. And there's a lot of...
Let me just ask you about that, because it seems to me like there's some types of litigation, some situations where a joint proposal would be appropriate and would preclude gamesmanship, and somewhere it would be inappropriate in that it would just allow for gamesmanship. And the other is true. There's some where individual proposals might be subject to gamesmanship, and some types of suits where, and they're outlined in the brief. So the question is, would it be inconsistent with substantive law, which just is very general, to say if some smart people like y'all could figure out in this type of lawsuit, a joint proposal is appropriate, and this type, a single is appropriate, and then have that laid out by rule in terms of the procedure by which we'll take this very general statute and make it applicable to various types of lawsuits. I mean, because to me, that seems like the kind of thing a procedural rule should do. It's not inconsistent with the statute at all. It implements it with the procedure. Do you view that, something like that, would you view that as substantive or procedural? That would be the question.
Your Honor, I would view that as a substantive matter because of the way, at least that Section 768.79 arranges these matters. Because it doesn't flow naturally from the statute. It's not an implication of the way that Section 768.79 works. 768.79, Chief Justice, I see I'm out of time.
You can keep going.
Thank you, Chief Justice. So the way Section 768.79 is supposed to work is to be a quick, simple, up-down settlement offer. And there are cases, the FJA certainly couldn't dispute, that there are cases where these joint settlement offers might be useful. And as Your Honor pointed out, we do discuss those in the comments. But to the extent it would be useful in a case, that's something that would be more appropriate for non-PFS settlement negotiations between the parties that a PFS could certainly spark and could certainly encourage the parties to embark on. But it's, per the omitted case canon, it's something the statute just does not consider. It's a void in the statute, and so it's neither a permission nor a restriction. It's just not there. And this court should not vary from the substance of statutes. And if there are no further questions, thank you very much, Your Honors.
Thank you.
Good morning, Chief Justice. May it please the court. I suppose I have 15 minutes to try to explain why we should fix a broken system, and I'll certainly do my part. As the chair of the Civil Procedure Rules Committee, we consider a lot of proposals that are provided to us from lower courts and practitioners and lawyers and judges or internally. This one came to us from this court. We did consider it, and I want to point out, this was in our comment, this is an important fact for this court to consider. This was a fairly unanimous committee vote on the comment that the Civil Rules Committee provided, which is not typical. Certainly in the last couple of years, there are very spirited debates because these rules do affect practice areas, practitioners, and litigants differently. There's no question that Rule 1.442, if applied in its current form or as the proposal seeks to apply it, will have result outcome differences for different groups. Notwithstanding, our committee, a very broad, diverse group of lawyers and judges were on board with the comment we provided. And that comment strived to really do one thing: try to make this rule. It is a broken rule. It's an awkward rule. There's issues. There's always going to be gamesmanship, right? We can't write a rule. We've tried to eliminate all games. We try to write the best rule we can. And so the comments that we provided really strive to give the court some guidance as to how best to accomplish the purpose of the statute, 768-79, and that is force settlements early. Settlements of cases that should settle, that are clogging the dockets of our courts, that are overcrowded. There was a comment and some discussion a few moments ago about you can always step outside of this procedure and just settle a case. That's true, but this is a carrot and stick function that conversation, the other conversation, the normal settlement conversation doesn't have.
Well, how on the attorney's fees issue that Justice Lawson and I were talking about earlier, how does that help settle cases? If anything, I would think it would stop it. I guess in a personal injury setting, you have your standard contract before filing suit. It's what, 33 1/3% fee?
That's what I understand, roughly.
Once suit is filed, is what, 40%? Plus
I think
cost?
they're all individual. I think they can, I don't do personal plaintiff's injury,
Okay.
but I understand that
I
is
assume
right.
that to be the case, just for purpose of the question, plus costs after that, and that's obviously not determinable. So, client, you settle a case for $100,000. The client, the case is in suit, lawyer's entitled to 40%. So now we know the client's going to get what, 60%, $60,000 less cost. So that's already kind of built in. When you start other cases where we go by hourly fees and things like that, that's when it gets really complicated. And those cases are usually determined collaterally later on in a separate hearing, where a judge has to make factual findings as to, whether the fees were reasonable and necessary and that kind of thing. How does adding that in there, why would a lawyer settle a case when his fee may not be anywhere near what it may be if we had a hearing later on?
I understand the question, and let me see if I can answer it this way. In the context of those conversations, I would just say in practice, there's typically a conversation that goes on in addition to just general experience. You're in the pretrial motion stage, the case has been litigated for 4 months. Most lawyers that practice in a particular area should have a good general sense of how much time has been spent on the case and how much fees are reasonable. And I would just say from personal experience, that conversation typically happens in that normal settlement conversation context. The rule that whether it's a fees included proposal or a no fees proposal, as the Civil Rules Committee suggests should remain in the rule, could account for that. Right? The offeror can make it a no fees proposal, and then they leave the offeree to taking that offer and splitting up whatever that contingency fee award or amount would be with their lawyer. They can resolve that later, or they can make it a fee award and explain, I'm offering plaintiff, your claim is worth $10,000. I'm going to offer you $15,000 or $10,000, and it's also going to include fees. I don't know that there's a requirement in the statute that a fee proposal that includes an offer for fees is only permissible if there's an entitlement to fees. An average personal injury case, there's no entitlement to fees to be paid by the prevailing party. They can make that proposal, and they can work that out in the proposal. So the offeree, the individual litigant, is going to get the $10,000, and the proposal will say, and we're going to give your lawyers $50,000. So it's a $60,000 offer of judgment, specifically outlining who gets what amount. So I think they can work around those issues. And that gets to the ultimate goal of resolving the cases early in the cases that should settle. Justice Lawson, you were asking questions about the joint proposal. That's an interesting rule, because this is a brand new rule, right? The Supreme Court's proposal to create C5 is a brand new rule, and our committee studied the Gorka, and we've sort of interpreted the Supreme Court's proposal that we're here to talk about as being essentially what the dissent was proposing in Gorka. Chief Justice Kennedy, right? I mean, I think that's right, but I do think, Justice Lawson, there's a way to do it, and that's what we proposed. What we proposed is take that construct, but make it apply only to particular types of cases where it really is workable. Current C4 in the rule applies to cases where there's undifferentiated damages, cases where those parties are going to be aligned, and what we've proposed, consistent with the Gorka dissent approach, is to make the offer available to those types of claims, allow an offeror to make it conditioned on mutual acceptance, and if one party accepts and the others don't, that one party is excused or will not be subject to the sanctions available under 768-79. That was the committee's best effort in this amount of time to come up with a workable rule and avoid, like we said, there are going to be games. Litigants will likely try to come up with more creative ways to do that.
Well, at the end of the day, whoever loses is going to litigate. I mean, that's just a reality of where we are, right? If you lose one of these rule statutory issues, then whoever loses is going to litigate. I think the purpose, at least as far as I'm concerned, of having these rules proposed is to eliminate the magnitude and the body of law out there that could possibly be litigated, and to try to eliminate some of that. I agree with Justice Warga that this is broke. The law in this area is a mess. It's an absolute mess from my perspective. And so I, for one, would like to see some change made to try to make it workable and to try to encourage settlements. So that's the purpose, at least, from my perspective.
Right, and I think that's a fair point, Justice Paulson. I think you're right. Whoever loses on the proposal for settlement process is going to litigate it because of what's at stake, whether, for the fees or potential malpractice claims. Right?
Can I ask you, I'm sorry.
Yes, sir.
So, and I don't know if you were just trying to be diplomatic in your filing, but is it your position that on this issue, on the joint proposal, that that the proposed rule actually conflicts with our court's substantive interpretation of the law? To the extent that it seems like the majority's position in Gorka, and they kept bouncing back and forth between the statute and the rule, but one way of reading Gorka is to say that the statute itself requires, offers that can be accepted individually. And it seemed like you came close to saying that what we've proposed would conflict with that substantively, but I just wanted to see if you wanted to clarify that.
Well, yes, we were being diplomatic, but we were also being, it's accurate. I mean, I think the way that I understand our comment on this issue is this court's proposal, it really does seem to be an adoption of Gorka's dissent, which would, by default, be an abrogation of the rule in Gorka. Meaning, Gorka said you can't make an offer of judgment or proposal for settlement conditioned on mutual acceptance because there's no opportunity to independently evaluate for each offeree what you're accepting.
And you view that as an interpretation of the statute? Because obviously, if Gorka is read as just being limited to interpreting the rule, then this rule could change that. But if it's an interpretation of the statute, then that's a separate question.
Our committee didn't see this as an issue outside the purview of the court to do, meaning that it's not substantive, it's procedural. We didn't take a position whether Gorka got it right or wrong. Well, all we said was Gorka majority controls. And so if you adopt...
But I think the question is, isn't Gorka interpreting not just the rule, but also the statute?
Oh, absolutely. I'm sorry. Yeah, no, it is interpreting the statute. That's
And
right.
to the extent that it did, then arguably we can't use a rule to override a substantive interpretation of a statute.
That would be correct. We didn't take a position on that. The committee, subcommittees, we didn't evaluate that at that level. We do think that this court, consistent with Gorka, could make the rule. We just think that adopting the current rule would...
Let me ask you this, counsel. This is kind of stepping back from all this. Given the way all these things interact, all the complexities, the questions about what's substantive, what's procedural, couldn't a case be made for it being time for the legislature to look at this and address these questions and try to come up with changes that would address the problems that have arisen, and then they can, substance is their arena, and they can make the substantive choices, and they can listen to people who come in with their different perspectives. So what do you say about that as being a really a more effective way to solve whatever problems, some of which are substantive, that exist in this arena?
If we had a magic button and we could ensure the legislature would get that on, absolutely, Chief Justice. But we're working with the rules that we have, and so I'm also involved with the COVID-19 task force, and we know that there's the work groups on judicial resolution and improved resolution of cases. Our courts are in a problem right now. They're suffering. The trial courts are backlogged now more than they were 2 years ago because of COVID. If we wait till the legislature,
maybe they do better. Maybe something we hadn't thought of, any of us.
no, I think they might, and I think they should, and I certainly think that's an appropriate vehicle. But for right now, we as the Rules Committee believe we should work with the rule we have, and in response to this court's proposal to make the amendments it made, we just provided our response and our comments to try to align them with that purpose, with that function. As a practical matter, and this is why I raised the committee's composition on the front end. We have lawyers and judges from all walks, from all areas of practice. And I think the consensus is you need this vehicle. You need proposals for settlement. They can be effective if they can be used in a manner that are going to be used. As a practical matter, if you don't include non-monetary terms, which was something the committee felt strongly should remain in the rule, as a practical matter, a lot of defendants are not going to use them. Like
Well,
that-
some of, like, you mentioned the liens, right? Let me ask you this. If you got a judgment, if the plaintiff got a judgment, and the judgment was to be satisfied, talking about the rules, so set aside the rule for a minute, right, the settlement issue. If the judgment was there, and the check is to be cut in satisfaction of the judgment, how does that check get cut? Who's it made out to? Is it made to the plaintiff only, or is it made to the plaintiff's lawyer, any preceding law firms, and any known lien holders? All included in the name of the check. How's that transmitted?
That's a great question. Unfortunately, I don't know the answer to that specific. I haven't seen a lot of checks cut at the end of the litigation, but I think, as I understand it from our discussions at the committee, Justice Polston, is when there's a check cut for a case that might have medical liens and issues of that sort, there is still a recourse against the payor of that check if there are unpaid liens, and those are concerns that were raised by the committee, the subcommittee, and those non-monetary conditions.
So all that is a matter of substantive law, is it not?
The effect of why you would need the non-monetary condition, in other words, yes.
And what does the check say, and when does the judgment get satisfied? All that's a matter of substantive law, not procedure.
Well, I think the same could be said for rules about the form of pleadings and service of process, right? Our procedural rules are going to necessarily
But whether a
affect.
judgment is satisfied by a check that's cut in a certain way and who's on it, I think the liens and how that gets satisfied, and whether or not how you actually pay that, whether it be by settlement or in satisfaction of a judgment, how that gets done, it seems to be a matter of substantive law. So the issue on non-monetary items, the release and all those different things seems more substantive than it does procedural.
And I see I have about 8 minutes left.
You can keep going.
Thank you, Chief Justice. What I would say is this: 768-79 does not expressly, it doesn't mention non-monetary terms. It's just silent as the non-monetary terms. So starting with that, there's no conflict with a rule as an initial matter because it's silent. The statute is silent on that front. And just like in the White versus Steak and Ale case, when the majority had to define judgment obtained, and they looked at the purpose and function of the rule, we would suggest that that's an appropriate approach here. Look at the purpose and function of the rule. These proposals for settlement, whether it's dealing with the lien issue on the non-monetary terms or a release, these are the sorts of guarantees that the defendants and the offerors, in practice, in reality, litigating every day, are going to want to get in many cases. And so if not having that ability, which shouldn't, it doesn't cost the plaintiff anymore. We agree there's a whole line of cases that talk about don't ask for a general release that asks the offeree to give up something outside of what's at stake in the litigation. There's a ton of cases that talk about that. What we're talking about is resolving what's at stake here, whether it's the medical lien issue and a release as to these claims. That's important as a practical matter. That would be consistent with the function and purpose of the statute, and the committee felt strongly that not having that a tool available to litigants would make the proposal for settlements less likely to be used.
One big one is confidentiality agreements that
Agreed.
a lot of people request. Would that be considered substantive?
I mean, there could be substantive components to what the confidentiality agreement could or could not permit, but the inclusion of it as a non-monetary term, the committee feels that it is not substantive because it's not creating a right or a rule that's inconsistent with the statute. The statute is just silent on it. It's a tool to get to that end game, which is get the cases settled. With that, Chief Justice, I appreciate the time. Thank you.
Thank you, counsel. We thank both of you for your argument